Ackley versus Kevin Ackley.
For the record, this matter is before the court for a continued pretrial conference. This hearing is being conducted via Zoom. President Attorney Ronald Bruce, representing the plaintiff Emily Ackley. Ms. Ackley, you are present audio. Is that correct, ma'am?
Yes, sir.
And defendant Kevin Ackley is also present. Good afternoon, everyone.
Good afternoon.
Good afternoon, Judge.
If the court recalls, the primary issue was that of paternity or revocation of paternity. Is that correct, Mr. Bruce?
That and supervising parenting time for my client.
Correct. The last order of this court, May 22nd, mother had supervised parenting time at Family Counseling Shelter Services. When her last before the court, the only issues were custody and parenting time. So the parties really made no progress then today. Is that correct?
No. Well, it's my understanding, Judge, that Mr. Ackley is still alleging that my client's rights were terminated, even though we adjourned it in March for him to provide documentation in regards to that. So I don't believe he's willing to agree to anything related to parenting.
Well, have you investigated, Mr. Bruce? Has there been an order entered by some court in some other jurisdiction that
I didn't find any
Washtenaw County? I'm sorry?
I looked in Washtenaw County. I didn't see anything. All I saw was there was a motion, there was a termination proceeding filed against both parties. Dad apparently was given the kids and the case was closed, but my client's rights were never terminated. I think that's what happened. Dad insists that my client's rights were terminated.
Okay, so I'm sorry, you do have a copy of this was it Lenawee County order? You have a copy of that?
I thought it was Washtenaw. I went online and I have a screenshot.
So do you have a copy of that order from the termination proceedings?
I have a screenshot, I think, of it, but I went online and looked and I didn't see anything.
I'm having a real hard time catching everything, Mr. Bruce. It's very echoey, and I'm sorry, I don't know if it's our system or if it's your system, but maybe getting a little closer, it might be a little clearer. I was having a real hard time catching everything.
I don't have a copy of the order. I have a screenshot from my client. I went online and confirmed it with the information that they have available. I didn't see anything else with my client's name on it, which I think there would be a termination trial, which there never was, at least that I didn't see.
Okay. Mr. Ackley, do you have a copy of a court order that terminates the plaintiff mother's parental rights?
As of right now, I've tried to get that order, and I can take care of these kids too much. Like, I work anywhere from 50 to 60 hours a week. And for me, just to get something, like I tried to turn in something for you to see on Friday, and I was barely able to make it to the courthouse before they closed because I work an hour away from where I have to turn this stuff in. And if this keeps going on, I'm going to have to hire my own lawyer to do my own footwork, because my lawyer, when I hire one, will be able to find that, will be able to prove it. Because if I had a lawyer on the other foot, like Emily, my lawyer would come to the door with the court paperwork. Like, I'm going to work and take care of these kids, and then I have to run over here to different times. I can't just take times off of work. I can't do this. I can't be my own lawyer. I've had one time where I was able to get to Washtenaw, and they're like, that paperwork's so long. Like, here's your last order, but our court dates were separated. So I think it's in Emily's stuff somewhere that states that she doesn't have any rights. And I just turned something into your county clerk stating something to do with this new kid that Emily just had. And I think it's page 2 of 2. It states everything that happened with Emily's first 2 kids and my sons, which she has no rights to any of them. And it states that in that it's not a court order, but it's something from a foster care agency.
Right. Without question, you should hire an attorney, Mr. Ackley. So what the court's going to propose, let's take the proof today. This case getting old. I'm going to take the proof to establish your jurisdiction. There's been a breakdown of the marriage, that Ms. Ackley is not now pregnant, and the court's going to reserve all standing issues. I think it's a wonderful, great idea for you to get the assistance of an attorney. We get to the bottom of this. Any objection to that, Mr. Bruce?
No, I think he should hire.
Okay, and we also have, Ms. Bruce, you are going to make inquiry and facilitate DNA testing with the alleged biological dad from state prison. From prison in Macomb County. Were you able to make any progress in that regard?
I talked to my client, Judge. My understanding is dad is not cooperative, or the presumptive dad, I guess, is not cooperative towards getting the DNA, and he's in prison.
This child was born during the marriage, correct?
Correct.
All right, so someone's got to file a motion to revoke paternity. Mr. Ackley, on Michigan law, you are the presumed to be the biological father of the three-month-old child, because the child was born during the marriage. Probably
Okay.
someone should have started the divorce a long time ago. If she has another child, you're also presumed to be the father of that child. So you need to have an attorney, and the attorney needs to file a motion to revoke paternity.
I got a phone.
That you are not the biological father of his child, and then we have to do DNA testing to do that. So this is a very complicated case. You definitely need an attorney, Mr. Ackley.
Okay. I had received a phone call about 2 weeks ago about somebody sending me a DNA test to take on this kid. I don't know if it was a receptionist from Mr. Bruce's law firm or who it was, but they said Emily was paying for a DNA test and I'd be sent one in the mail.
Ms. Bruce, didn't know anything about that, Mr. Bruce?
I don't think they would have mailed him anything. We probably called because the parties were going to split the cost of the DNA test in Toledo. I think we probably are calling to see if he was still willing to do that. But my understanding is he wasn't.
Excuse me, may I interrupt for a second?
No, you talk to your attorney, Miss. The court's going to take some proofs this morning, and we're going to adjourn the matter so that Mr. Ackley can hire an attorney. Mr. Ackley, for the record, did drop by this morning to the county clerk, and I'm seeing it for the first time. It's a family case plan from the Ohio Department of Job and Family Services. It references the name of Emily Ackley, and it talks about Kylie, the 3-month-old child, would benefit from a developmental assessment. The child apparently is experiencing some issues. Mr. Bruce, I'm not sure. I don't know if this is the Ohio equivalent of the Department of Health and Human Services, but it does state in this report, page 2, that Emily lost custody of her older children in Michigan due to mental health and substance abuse issues. And that there's also been that Emily has been diagnosed with some mental health issues. This agency has concerns about the ability of Emily to safely parent her children and being truthful about her substance abuse and mental health issues. So no, I don't know if the state of Ohio is taking jurisdiction over this child. Do you know anything about that, Mr. Bruce?
No, I've not seen that.
Okay. You may want to ask your client. So it appears that the Lucas County Children's Services is involved. They are performing an assessment.
Is there a date on that?
Yes, it is dated May 16th, 2024.
I mean, I know my client's currently receiving services from their version of DHS.
It suggests that the child is at risk in the care of the plaintiff, your client.
That case, they told me that I am completing case service plans from what I didn't finish with Silas and Kiefer, our sons. So the concerns with the substance abuse and things like that, those were from years ago when we first started the case, the DHS case with Silas and Kiefer. And now they want me to complete those case service plans because I did not. And that case is actually going very well. I can get that information if you guys need it.
Well, it's obviously, I'm not sure what happened that brought you to the attention of Lucas County Children's Services, but something must have happened, Mr. Bruce. And again, obviously, if the agency is concerned about plaintiff's ability to care for this 3-month-old child, that's obviously relevant to custody of the two older children of these parties.
I guess somebody had called from Michigan to inform Ohio that I was having another baby and I didn't complete case service plans up there. So they came to tell me that, I needed to complete my case service plan, which I am now currently doing.
Right. And we're still at the same point we were back in March, Ms. Bruce. We've not moved forward at all. So the court needs assistance of counsel. I don't have time to investigate and call these agencies, get court orders. So in any event, we're going to take the proofs. We're going to adjourn this. And at some point in time, presumably your client wants to get divorced. Maybe you can dig into this, Mr. Bruce. Mr. Ackley, you'd be well advised to retain an attorney. That attorney can work with Mr. Bruce and let's uncover some of this stuff. So all it's going to do is, again, and there's no other issues, correct? There's no issues of property, Mr. Bruce, no joint debts. The only
No
issue is
joint parties agree to that.
Well, in this court's opinion, I mean, why can't the parties have joint legal? And joint legal, Mr. and Mrs. Ackley say that if the child needs elective surgery, important decisions, you have to contact and share equally those decisions. So in this court, it's just a joint legal and then parenting time. So all we got to do is agree upon a parenting time. The children are 8 and 7. Who do they primarily reside with right now?
They have resided with me for the last 7 years.
Okay. Again, I think it's just a matter of just to determine parenting time for mom, Mr. Bruce. We don't need to put the label of physical custody, but we can say the dad should be the primary caretaker of the children and establish a parenting time schedule for mom and then address paternity of this 3-year-old child, and the parties could get divorced.
I don't believe Mr. Ackley is agreeable to any time for my client. That's
Okay, is Miss Ackley, has she started supervised parenting time at Family County Shelter Services?
She's not.
She's on the waiting list?
She has supervised time in Ohio with her other kids. She wanted to know if the court would consider allowing her to have supervised time in Toledo, if she can have someone pick up the kids from Mr. Ackley and take them back to Mr. Ackley.
Did you discuss that during the course of mediation this afternoon?
I believe Mr. Walker did bring that to Mr. Ackley's attention.
Okay. Was it discussed?
We were in separate breakout rooms, but my understanding was that Mr. Ackley is not agreeable to my client having any parents.
So what's the status with the court entered an order? The mother shall have supervised parenting time here locally, Family County Shelter Services. Has that started? Apparently not.
No, it has not.
Is Miss Ackley on waiting list?
Yes, I am on the waiting list for that. I was wondering if I could do that supervised parenting there as well as Wednesdays for an hour here when I get supervised parenting time here with Kyla as well.
Did you ask Mr. Ackley about that?
He will not speak to me, and the mediator
Hey,
told
Mr.
me.
Ackley, what about that proposal?
I'm not comfortable with my sons going to anything until the whole issue about her having rights is determined. I brought it up to my sons that they might have to see this woman, and they didn't like it very much, and it made me very uncomfortable. So I'm not okay with it until it's established that she don't have any rights, and then we can just get on with this divorce.
Okay, someone's got to track down orders, Mr. Ackley or Mr. Bruce. The court will continue the order. The prior order is that mother shall have supervised parenting time at Family County Shelter Services, supervised here locally. So once they've got the eligibility, once they, Miss Ackley, you should contact them and see where you're on the waiting list. And once they do that, then yeah, Mr. Ackley would have to take the children to that agency. It'd be a supervised parenting time. And then that agency would provide written reports. It's usually 1 hour a month to Mr. Ackley. So that will continue until this court has an order that mom's rights have been terminated. That order will continue. So Mr. Ackley, yes, this court's not going to order for you to have the children go to Ohio. They'll be here locally in Monroe. And Mr. Ackley will drop off the children there and pick them up for your hour of parenting time. All right, Mr. and Mrs. Ackley. We're going to take some proofs. They'll stop the court's clock, and the court we can adjourn this maybe 6 weeks. Mr. Ackley can track down paperwork. Mr. Bruce can track down paperwork. We can do DNA testing. At some point in time, we need to do DNA testing, Mr. Ackley. Are you going to show the cost of that?
Sure.
Okay, it's about $250 a person. So Mr. Bruce,
I'm not able to get food stamps or anything right now. I'm paying for formula and
Right.
everything, my baby out of pocket. I do not have the money right now.
Okay.
I was going to come up with the money on my own, which takes me a lot of extra work. If Kevin was more willing to work with me about parenting,
if you can borrow
time.
some money, ma'am, unless Mr. Ackley is willing to front that cost. It said Mr. Ackley benefits you considerably because you're right now, this child, you're on the line to support this child until you can get DNA testing showing that you're not the biological father of this child.
Right. Which I would
So,
go just to get it out of the way. But like, I'm gonna have to hire a lawyer, and then I have my own bills at my own house, and then I have my own other kids that I take care of. But I think you said we're gonna make this out to be six more weeks. I think I'm gonna need probably a little more time than that right now to establish a lawyer. The last lawyer that I had gotten, it cost me $2,000 out of pocket.
just so you know, if Ms. Ackley has another child, we're further complicating things. Yeah, you both need to move forward with this divorce, actually get divorced. So I guess we can make this off for 8 weeks, but you've got to talk to Mr. Bruce's office, do DNA testing in the meantime. That doesn't happen overnight. You can do that. That's probably your first priority rather than having an attorney. Do the DNA testing so that you can determine this child is not your child, Mr. Ackley. Someone's got to file a motion. You got to file a motion. It's called the motion to revoke paternity. Make a note. You got a piece of paper and a pen there?
Motion
to revoke paternity.
To revoke paternity?
Or Mr. Bruce, are you going to file such a motion or not? Someone's got to file a motion.
I'll file it, Judge. I thought there was an agreement he was gonna, I'll file the motion.
Okay, but somebody needs to file the motion, get probably before the court. So file the motion, Mr. Bruce, to will indicate the record reflect. Mr. Bruce is going to file a motion to revoke paternity, and Mr. Bruce can reach out to you to schedule DNA testing, even if you got to front the costs. And Mr. Ackley, let's get that done. And Mr. Bruce, you can find out from the front of the court when someone comes to our house, so you can go parties can schedule appointment with DNA diagnostics. I think they have a facility in downriver. They come to the Monroe County Courthouse once a month. I don't know if they have an office in Lucas County where your client apparently resides. So get that, and then somebody's got to track down paperwork on this termination of parental rights issue. Any event, Mr. Ackley, can you both please raise your right hand to be sworn? Mr. Ackley, do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. Mr. Bruce, you want to take the proofs from your client, please?
Yes, Judge. Ms. Ackley, you recall coming to my office having a complaint for divorce filed in this case, correct?
Ms. Ackley?
I'm sorry, what did you say?
Listen, please pay attention.
You came to my office and had me file a complaint for divorce in this case, right?
Yes.
And you lived in the county of Monroe. Dad lives in the county of Monroe for at least 10 days in the state of Michigan for 6 months, correct?
Yes.
And at the time you filed, there were 2 minor children, you believe, born between you and your husband, Silas and Kiefer, correct?
Yes.
Since then, you had another child, correct?
Yes.
You're not currently pregnant, correct?
No.
And would you state that there's been a breakdown in your marriage such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
I'm sorry, what did you say? It's kind of hard to hear.
There's been a breakdown in your marriage, correct?
Yes.
And you don't believe that your marriage can be continued, correct?
Yes.
And if the judge weren't to grant you a divorce, you wouldn't reconcile and get back together with Mr. Ackley, would you?
No.
I think that covers it, Judge.
All right, thank you. Mr. Ackley, can you please state your name and current mailing address, please?
My name is Kevin.
Mr. Ackley, did you hear the testimony of your wife Emily this afternoon?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Mr. Bruce, do you have any questions of Mr. Ackley?
No, Judge.
All right, based on the testimony that has been presented this afternoon, as well as plain file in this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, the court will reserve the outstanding issues, which is basically whether or not the maturity of this 3-month-old child that needs to be addressed, and as well as a mother's parenting time. So, Ms. Ackley, you should contact Family Counseling and Child Services, find out where, make sure you're still on the waiting list, that they haven't lost your name in that waiting list. Hopefully, Mr. Ackley can track down a copy of any order terminating your parental rights. Until the court sees that, the court will assume that she still has parental rights. Mr. Ackley, when does last time she even saw the children? You're saying she hadn't seen the children in 6 or 7 years?
Yeah, last time that she's seen them, they're in foster care.
Okay.
No, that is not true. Me and Kevin,
All right, you can talk with your attorney, Ms. Ackley. Again, we're not addressing parenting time today. The court's not going to order anything more than continue the prior order of this court, that your parenting time should be supervised at Family Counseling and Child Services. You've got their phone number. Call them to find out where you're on the waiting list, and they will reach out to Mr. Ackley. Mr. Ackley, have you completed the intake with that agency?
No.
Okay, because the last order of this court is that both of you complete the intake. You need to call them, just say who you are. They'll just ask you questions over the phone. What's your address, your phone number, and so forth. I'll give you the last order that was contained in the last order of May 22nd, 2024. Do you want their phone number again?
Yes.
It's 734 area code 241
241
0180.
0180. Okay.
Right. So call and just say who you are. You're there to complete an intake. And that should take care of things. At least then you've done what you've been ordered to do. Finally, let's set another pretrial conference date.
Judge,
the parties can come do the DNA testing in the meantime. So, Mr. Bruce, maybe you can determine where the testing can be done. Mr. Ackley may be willing to front the cost, or just even pay the whole cost if Ms. Ackley is unable to do so. That DNA testing done. So, Mr. Ackley, you're suggesting 2 months?
Yeah, hopefully I'll be able to get something together by 2 months. And can we also do it after 2 o'clock? Normally I work till about 2 o'clock. Sometimes it might be 4.
Sure. Yeah, we can do it later in the afternoon. How about Thursday, September 19th, Mr. Bruce, in the afternoon? Maybe 3 o'clock will work with you, Mr. Ackley?
Yes, Your Honor.
What day, Judge?
Thursday, September 19th at 3 p.m.
Oh, that's fine.
Right, the court will mail out notice of a continued pretrial conference. Thursday, September 19th, 3 p.m. I'm going to give you a Zoom once again. Hopefully the parties can make some progress. So, Mr. Ackley, you can always reach out to Mr. Bruce and get the DNA testing done. There's a firm called DNA Diagnostics. You can Google them. They can tell you where their facilities are. Then both you have to submit to. It's just a con swab test, real simple test. But it's a certified testing facility. And that's just that you have to be tested and the minor child. So Ms. Ackley will have to take the child to this facility. And if you both go to the same facility, it's a lot easier if they collect the sample. Doesn't have to be the same day, but at least same facility. So you may want to go online, just DNA Diagnostics. Mr. Bruce, if you can help in that regard, Mr. Bruce, you're going to follow them and make note you're going to follow the motion to revoke paternity. If you can send a copy of that motion perhaps to Mr. Ackley along with information how to contact DNA Diagnostics, and the parties can he can maybe determine where he wants to do the testing or what's convenient for your client. Your client lives in Toledo, is that correct?
Right.
I don't know if there's a facility in Toledo, but you can check that out, Mr. Bruce, and give some direction to Mr. Ackley. Hopefully we'll get that done when we come back.
There is.
Okay, any other questions, Mr. Ackley?
No, Your Honor.
All right, that concludes the matter. You can all zoom out. We'll see you on September 19th at 3 p.m.
Thank you.
Versus Joseph Zinder.
For the record, this matter is before the court for continued pretrial conference subsequent to mediation with Ms. Pratt from the front of the court. This afternoon, present is our attorney Kirsten Nemec representing the plaintiff, Catherine Zinder. Ms. Zinder appears to be present. In addition, attorney Anthony Brusco is present representing the defendant Joseph Zinder, and Mr. Zinder appears to be present with Mr. Brusco. Good afternoon, everyone.
Good afternoon, Your Honor.
Have the parties made any progress toward their own resolution this afternoon?
We have, Your Honor.
We have, Judge.
Wonderful. Who would like to place agreement on the record?
I can, Judge.
Please, Mr. Brusco.
Thank you, Your Honor. Judge, the parties are going to share joint legal and joint physical custody of the minor children. Mother will have the children on her days off. Father will have the days that mother works. Father will return the children to mom, or mom will pick them up no later than 8 p.m. on 8:30 p.m. on school nights. If mom provides the transportation, pickup will be at 7 p.m. Pickup and drop-off schedules will be split evenly, so neither parent is obligated to assume all the transportation responsibilities or as agreed by the parties if there is a deviation. On the weekends that the kids will be with dad, he will get the kids after school on Friday, and they will need to be back to mom's house no later than 8:30 p.m. Sunday night. Transportation will be shared as necessary. If mom is requested to pick up the kids, dad will give her notice by 4 p.m. The kids should be fed and ready for bed and showered if necessary when they're either dropped off or picked up by mom. Child support has been calculated to be $1,233 per month. That's going to commence either on August 1st or when mom moves out of the marital home. She's in the process of buying a home, so we're not exactly sure when that's going to close, but we do think it's going to close at the end of this month. Moving out is the controlling date. The parties are going to split uninsured medical expenses, with dad paying $60 and mom paying $40 after the first $454 per child per year has been paid by mom. There are retirement accounts. Those accounts shall be split 50-50 by way of qualified domestic relations orders if necessary. Those orders shall be prepared by Ann Pastrana, absent an agreement to the contrary. If the accounts can be equalized with using just one quadro, that would be acceptable. All costs regarding the quadros and any administrative fees would be shared equally between the parties. The birthdays and holidays and days of special meeting will be as agreed by the parties. If no agreement can be reached, the default will be the front of the court holiday schedule. The parties agree to discuss vacations with at least 2 weeks of notice ahead of time. Neither will exceed 10 days of consecutive vacation time, where the other parent will not see the children for more than 10 days. In the event of a conflict on choosing vacation days, mom will have even years where she gets first choice. Dad will have odd years where he gets first choice. There's a marital home. Dad is going to keep the marital home, and he's going to refinance same, taking mom's name off the mortgage and cashing mom out of her equity in the marital home. That should happen within 90 days of the entry of the judgment of divorce. He will pay mom $60,000 as and for her share of equity in the marital home. Again, that payment should be made at the time of refinance or within 90 days of the judgment entry of divorce. It is believed that all credit card debt is in dad's name. He's going to keep that debt, and he'll be solely responsible for same, and she'll hold mother harmless therefrom. The parties have a joint cell phone plan that is in mom's name. They're going to cooperate to allow dad to remove his phone number from the plan and take whatever steps necessary to accomplish that and allow mom to keep her account as is. If there's any issues or termination fees or conflict as a result of this process, that issue will be reserved for a later dispute. Either party can petition the court for relief relating to that issue. We do not believe there's going to be any issues. Dad's going to pay off his cell phone bill within 90 days of the entry of the judgment of divorce, and he's going to take his number with him. Father will be removed from mother's auto insurance policy by August 1st of this year. He's to obtain his own policy of automobile insurance. Mom can keep the automobile insurance policy she presently has in place. There are joint bank accounts. Those are going to be closed, and the money is going to be evenly split. We expect the parties to be able to accomplish that within 15 days to allow for mom's last direct deposit to go into the account so she can make the appropriate changes to get her paycheck deposited into a new account. Each party will be responsible for their own health insurance as of the entry of the judgment of divorce. The children shall remain on dad's health insurance policy. He's to instruct and notify his human resource department of the judgment of divorce when it happens to let them know of the change. There are some automobiles and motorized vehicles in this matter. The 2017 Ford Fusion is awarded to mom. The 2004 Ford Explorer is awarded to dad. The 1977 14-foot aluminum boat and trailer are awarded to dad. There's a riding lawnmower that is going to remain with mom, and same as being awarded to her. There's a bunch of personal property that the parties are comfortable they will be able to divide without the assistance of counsel or this court. In the event they're unable to divide anything, they shall document their disputes and submit their disputes to binding arbitration with attorney William Godfrey. Notice of the binding arbitration should be given to each other and to attorney Godfrey by October 1st of this calendar year. I believe that is the entire agreement.
Thank you, Mr. Brusco. Ms. Nemec, did Mr. Brusco accurately state your client's agreement?
Yes, with one clarification and one addition, which we failed to address while we were in mediation. The clarification is regarding the cell phone, Mr. Zinder's cell phone. Our understanding was that it would be paid within 90 days or at the time of the closing, the refinance of the home, whichever occurred sooner. And then Ms. Zinder would like to have her maiden name restored. Catherine, can you spell that for me for the record?
Tolles.
B as in boy, Olles?
T as in Tom.
T, Tolles. Okay. So she would like the name Tolles restored to her.
Mr. Brusco, are those additions, clarifications acceptable?
Absolutely, Your Honor.
Well, Mr. and Mrs. Zinder, will you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I do.
Thank you. And I'm sorry, we did address spousal support, Mr. Brusco.
Same as forever barred, Your Honor, as to both parties pursuant to Staples v. Staples.
Thank you. Right, Ms. Nemec, if you give with Ms. Zinder, please.
Yes. Katie, can you state your full name for the record?
Catherine Marie Zinder.
And you are the plaintiff in this action for divorce, correct?
Yes.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days and in the county of Monroe for at least 10?
Yes.
You and Mr. Zinder were married March 21st, 2009, correct?
Yes.
And you have 2 minor children, Logan
Yeah.
and Liam,
Yes.
and there are no other minor children of the marriage.
Nope.
And
No more.
you're not currently pregnant?
I am not pregnant.
Okay. And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no likelihood that the marriage can be preserved?
Yes.
You heard the agreement that Mr. Brusco read into the record?
Yes.
Did you understand it?
Yes.
Do you have any questions about it?
No.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Is anyone forcing you to enter into it?
No.
Okay. Do you believe that the provisions related to custody and parenting time are in Logan and Liam's best interest?
Yes.
Do you believe that the property division agreement is fair and equitable?
Yes.
And do you understand that by placing the agreement on the record today, it becomes binding on you? Even though we haven't had a document that we've prepared that everybody has signed, when you put it on the record today, the agreement's binding. You can't come back and change it later.
Yes.
Okay. And so for example, with regard to spousal support, you could come back tomorrow or 5 years from now and ask the court to award you spousal support.
Yes.
Okay. You understand that you could have taken the case to trial and the outcome could have been different,
Yes.
but rather than going to trial, you're asking the court to adopt this agreement and turn it into a judgment of divorce. Correct?
Correct.
Okay. Have you disclosed all of your assets and liabilities to Mr. Zinder?
Yes.
Okay. Are you satisfied with my representation?
Yes.
And my final question, we're just a little bit shy of the 6-month waiting period. Are you asking the court to waive the balance of the waiting period and enter the judgment of divorce?
Yes.
And is that because you believe it's in yours, Mr. Zinder's, and the children's best interest to have some finality?
Yes. I think we should all move on.
Okay. Thank you. I have nothing further, Your Honor.
Thank you, Ms. Nemec. Mr. Brusco, do you have any questions, first of all, for Ms. Catherine?
No, Your Honor.
Okay, questions for Mr. Zinder, please.
Thank you. Joe, did you hear all the testimony provided by your wife here this afternoon?
Yes, I did.
Do you believe that her testimony was truthful?
Yes.
Did you hear all the provisions that I placed on the record regarding the custody of your children, the parenting time, and your property settlement?
Yes.
Are these the provisions regarding custody and parenting time that you want this court to adopt as your provisions moving forward?
Yes,
All right. And do you believe they're in the best interest of your children?
I do.
Okay. Regarding the property settlement, have you had enough time to evaluate this property settlement, and do you believe it to be fair and equitable?
Yes,
All right. You understand, we could have scheduled this for a trial at some point in the future, and we could have submitted all these issues to Judge Braunlich, and he would have decided them. Instead, you're asking the court to adopt the agreement that we just placed on the record, correct?
correct.
You could have done better or worse at that trial, but you understand that by resolving it this way, you've avoided future litigation, future fees, time, effort, heartache, etc. Correct?
Correct.
Okay. Have you truthfully and accurately disclosed all of your assets and liabilities in the course of these negotiations and all the discovery that we've been exchanging with the other side?
Yes.
Okay. Has anybody forced you to enter into this agreement?
No.
Is this your agreement?
Yes.
Have you had plenty of time to talk to me about this?
Yes.
Are you satisfied with my representation?
Yes.
Okay. Did you have any questions about the agreements that have been placed on this record?
No.
Okay. You too understand that this divorce technically can't be finalized until August 12th unless you and your wife both consent. Are you asking the court to also waive the 180-day rule?
Yes.
And for the reasons that were stated on the record, because it would be in the best interest of the children, giving both parties an opportunity to move on and begin their fresh start, are you also suggesting that you'd like to waive that 180-day rule if we submit the judgment to the court before then?
Yes.
Okay. I have nothing further, Your Honor.
Thank you, Mr. Ruskell. Ms. Nemec, do you have any questions of Mr. Zinder?
No, I don't. Thank you.
And you'll prepare the judgment, Ms. Nemec?
I will.
Thank you. Very well, the court would like to thank and acknowledge Ms. LaPrade for her assistance this afternoon, as well as, of course, attorneys Nemec and Ruskell for helping facilitate ample resolution of this matter. And the court would applaud you, Mr. Zinder, for reaching your own agreement. Without question, the best resolution of matters of this nature are ones in which you both participate and ultimately agree upon, far better off than having the court make these decisions. The court will, in fact, waive the balance of the statutory waiting period upon the request of both of you. Enter the judgment divorce upon as soon as it's been received by the court. Based upon the testimony that's been presented, as well as the plain father's case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony has been destroyed, and there appears to be, unfortunately, no reasonable chance of reconciliation. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. That'll conclude this hearing. Everyone can zoom out and have a good rest of the afternoon.
Thank you,
Thank
Your
you,
Honor.
Your Honor.